Welcome to the Supreme Grammar Podcast, where you can learn to write like a Supreme Court Justice. With me, Jill Barton. In today's episode, our AI hosts describe how to write the very first part of the IRAC or CREAC, the issue and conclusion statements. Let's listen in.
Welcome to the Deep Dive. Today we're charting a course, really, trying to give you a clear roadmap to mastering objective legal analysis.
That's the plan. We want to help you navigate any legal issue with, well, more precision and confidence.
Right, and we're focusing on two sort of foundational pillars.
Exactly.
Yeah.
Crafting a clear issue statement, sometimes called the question presented, and a precise conclusion or brief answer.
Okay.
These are really the crucial first step. Getting these right gives you a huge head start in, well, understanding how lawyers actually think and write.
So let's talk about objectivity. It sounds like it's more than just, being fair. You mentioned it's strategically smart. How does looking at opposing views make your own case stronger?
Yeah, that's a great question. I mean, objectivity is almost like your superpower in this context. It means you have to confront facts that maybe don't fit your first impression, or law that might not seem helpful to your client initially. And this whole process, it forces you to identify and really think through every argument, the counter-arguments.
Even counter-arguments to the counter-arguments.
Yes, exactly. And just as important, it means being aware of your own potential biases.
Yeah.
Welcoming different perspectives. It sharpens your critical thinking like nothing else.
Right.
And that is how you build a truly reliable prediction of what's most likely to happen legally.
That sounds incredibly tough, though. Especially, when you really believe in your client's side. How do you mentally switch gears from advocating to assessing objectively?
Well, it's definitely a discipline, kind of like trying to argue against your own favorite sports team, maybe.
Yeah, I can see that.
But honestly, that tough self-challenge, that's where the real strength of your analysis comes from. It means you're building something robust, something that can actually withstand scrutiny.
Okay, so we understand the why. Let's get into the how. You said the first step is nailing down the exact legal question.
Precisely. The issue statement. It pinpoints the specific legal question you need to answer, and it acts like a placeholder for your conclusion, especially in that IRAC's structure, issue, rule, application, conclusion.
Got it.
Now, for more formal stuff, like legal memos or briefs, you'll often see it called the question presented.
And that's different how?
It's more detailed. It combines that precise legal issue with the key legally significant facts of the case. So step one is always identify the precise legal issue, narrow it down.
Like your example, not just will the conviction be overturned.
Exactly. But something specific like whether Miguel Perry's compound qualifies as curtilage under the Fourth Amendment. Much sharper.
Okay.
Then step two is developing that full question presented. First, you identify the anchors.
Anchors.
Yeah, the core legal tests or criteria a court would use. For curtilage, maybe it's things like, is the area enclosed? How is it used? Stuff like that. Then you use those anchors to find the legally significant facts, and this is key. Those are the facts that, if you change them, might actually change the outcome.
And you need facts for both sides.
Absolutely. You have to objectively find facts supporting both sides of the issue. That's crucial for objectivity.
So what does a good question presented look like? Are there common formats?
There are. A really common one is the under does when format. Think. Under the law, did a party do an action when these key facts happened?
Can you give an example?
Sure. Under New York contract law, did the owner of a widget business make a binding offer to sell the business when she placed an ad, but she mistakenly priced the business for a fraction of its worth? See? Law, issue, key fact.
Okay, that's clear. Are there others?
Yeah, sometimes you'll see a multi-sentence format or one starting with whether, but the goal is always the same. Combine that precise legal issue with only the really significant facts. Crystal clear.
This is fascinating. And you mentioned even Supreme Court justices use these.
Oh, absolutely. It gets really interesting there. Think about Scalia and Kagan. In Florida v. Jardines, Scalia framed the issue around whether using a drug-sniffing dog on a porch was a search.
Okay.
But in Florida v. Harris, Kagan framed it differently whether a dog's alert gave probable cause. Same general area, different questions.
Wow. So the way you frame the question itself can really steer the whole analysis.
Exactly. It subtly shapes the entire discussion. It shows the power you're harnessing just by crafting that question carefully.
Okay, so framing is vital, but that's just setting up the problem. What about delivering the answer objectively? The conclusion.
Right. So your conclusion is basically the very first sentence of your objective analysis, especially in survey fact conclusion, rule, explanation, analysis, conclusion. It gives your direct answer and the main reason why.
And in formal documents, that's the brief answer.
Correct. The brief answer directly responds to your question presented, usually starts with a qualifier, like probably yes or probably not, because legal analysis is predictive, not certain. Then it quickly summarizes the relevant rules or anchors and explains your reasoning without just restating all the facts from the question.
So for that widget example.
A brief answer might be something like, probably not. An advertisement is generally seen as just an invitation to bargain, not a binding offer. And especially here, where there's a clear mistake the other party likely knew about, enforcing it would probably be seen as unconscionable. It hits the key points quickly.
And for the main sort of overall conclusion sentence.
Often it's quite simple. State your answer to the legal question because of your main supporting reasons.
Yeah.
Like, Sandra Lee probably did not make a binding offer under New York law because she priced the business so low that buyers would likely know it was a mistake. Direct answer, core reason.
So mastering these first steps, the issue statement, the question presented, the conclusion, the brief answer, that really sets the stage for everything else.
It absolutely does. It gives you a solid foundation for basically any legal document you'll write.
Framing the legal question and then figuring out what conclusion a court would draw is a crucial first step for any type of legal analysis. It will be the first thing your reader sees in anything you write, so make it count. Thanks for listening, and remember, you can be a great legal writer.